case briefs, and so much more. LSData's got what you're looking for.
In a 2004 case, Air Brake Systems, Inc. v. Mineta, the United States Court of Appeals for the Sixth Circuit focused on the authoritative interpretation of safety regulations and whether advisory opinions provided by the National Highway Traffic Safety Administration, NHTSA's chief counsel, are considered final agency actions and have the force of law. The case arose when Air Brake Systems tried to sell its non-electronic anti-lock brake system to a trailer manufacturing firm. The safety standard in question required vehicles with air brakes to have an anti-lock brake system with an electrical circuit capable of signaling malfunctions through an external warning light. Air Brake filed a lawsuit against the Secretary of Transportation and the NHTSA after they determined that Air Brake's system did not comply with the standard. However, the court found that the opinion letters issued by NHTSA's chief counsel did not constitute final agency action regarding compliance with the standard. Instead, they reflected the final agency action with respect to the chief counsel's authority to issue the letters. The court ultimately ruled in favor of the government and affirmed the district court's judgment, stating that the chief counsel's opinion letters to manufacturers were not final agency action and did not conflict with notice and hearing requirements, as they were only advisory opinions.
Case briefs, and so much more. LSData's got what you're looking for. Visit LSD.law, elevate your mind. Leave the stress of class.